Well, hello. My name is Douglas Armstrong, and I'd like to welcome you on behalf of Terra Firma to our annual licensing conference. Sorry. This conference is being recorded today, and in relation to the slides and handouts, they will be sent on to everyone who's in attendance today. As you probably know, Terra Firma have a number of advocates who are involved in specializing in licensing, and we have two of our leading lights here today. In addition, can I, and I'm sure you all know Emma Potter, our practice manager, but Emma's sitting in the front row today, and it was Emma who's organized this event. In fact, I'm going to quote from Chambers what they say about Emma. Emma is fantastically helpful, and so you are. So if there's any questions you want to ask about instructions or who to instruct, then please feel free to speak to Emma afterwards at the drinks reception. And I hope you'll all join us for a drink at the end. Anyway, on with the show. And our first speaker is Dennis Edwards, who's recognized both north and south of the border as an expert in this area of law. And I'll pass straight over to Dennis.
So first thing to just test is that the technology works, so that I can work it on it. Oh, there I am, yes. Excellent. Right, so a rather hackneyed title for this in the end, location, 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 because what I just wanted to talk about is something about the general part of this subject, which is the key importance of locality in various areas of licensing law. And I am keeping it pretty general, partly for my own benefit, but also because I know that Scott is going to move on after me to talk about something a bit more general, but which obviously still raises some issues of locality. So the overview then is there that location is a central feature of most, if not all, licensing applications. And when considering a location, it's very important that the decision maker, but also obviously the applicant, is able to define a locality. There's an element of certainty involved in that. Of course, you need to be able to know what the ground rules are, literally, in relation to what issues the application might raise. Obviously, there's a particular issue about the definition of locality in relation to alcohol licensing, and specifically concerning over-provision policies. And that's been the subject of a number of cases over the years, both before the 2005 Act and after, and indeed Scott has been in many of them. In turn, when it comes to making applications to licensing boards or having hearings about an application, an issue about local knowledge, of course, will arise, and that will be the local knowledge of the decision maker. And that then raises a question about how much the decision makers must share with the applicant. The applicant may or may not be from within the local area. And that raises the question about the extent to which the usual rules of public law in relation to fairness, procedural impropriety, fair hearings, natural justice, whatever you want to call it, the extent to which that arises in the decision-making process. Now, obviously, it is an area of public law, and therefore, in principle, the rules of natural justice should apply to the decision-making. But local knowledge is, of course, in the eye of the beholder, and just exactly what the limits of the decision maker taking into account local knowledge are is without sharing the particular matter that they're thinking about with the applicant is a tricky area, and it's not quite so clear cut, I don't think, as maybe it should be. Now, as far as the decision maker is concerned, or more specifically in relation to policies, there will often be duties to consult. These may be express statutory duties, or they may arise at common law. And I sort of ran out of time, like the poor student. And when it came to special events licenses, I didn't really reach that very much, except to make some general points. Although actually, in thinking about this, it was where I started, because there was I thought an interesting English case, which I couldn't find any direct Scottish comparator, but it may be that there is. But beyond saying that Section 40 of the Civic Government Act, Scotland Act 1982 substantially governs applications for special events licenses, and raising some questions about the duties to consult in relation to those, I'm not going to really say very much about them. Although it's obvious that the location of a special event is a particularly material consideration in relation to applications for licenses for them. So what role then, well, why is there a role, to be elemental about it? Why does location have such a significant role in licensing? Well, it's a little bit like the interface, I suppose, in planning, licensing, and the law of nuisance, that what makes location very important is that it gives the license holder the statutory authority to undertake the activities in accordance with the license without committing a legal wrong. Were it not for the license, things such as noise, litter, commotion, pollution could give rise to a common law nuisance, or more likely a statutory nuisance, or potentially both. And that then would, of course, give rise to a problem for the business. So the location of activities, as I say, is central, and it's going to be a very important feature of the decision-making process, and also any consideration that the court will give to the matter if the decision is challenged. And there is, of course, this marvelous quote from, I think, well known, from Sturges and Bridgman in relation to what a nuisance is, that what would be a nuisance in Belgrave Square would not necessarily be so in Bermondsey. Now, that was made in 1879, and I very much doubt that a judge today would put it in quite those terms, not least because Bermondsey has changed, although it's fair to say so has Belgrave Square, perhaps to the point where most of the owners of the houses and apartments in Belgrave Square would consider a half bottle of alcohol to the over-provision, I would have thought. My point being that it's the House of Saud, I think, that owns most of Belgrave Square these days. Now, the point, though, I think there has been put in different ways by judges over the years. And of course, what's revealing about it is that just as for nuisance, also for licensing, what might be acceptable in the locality of Belgrave Square or the New Town will not be so acceptable elsewhere, would not be similarly acceptable elsewhere. So the location of the relevant activities is a key consideration, it seems to me, not just for nuisance or for planning, but also in relation to the grant or renewal of licenses. Now, in many contexts, the law makes this explicit, but in other contexts, I think it's implicit. Now, this is not an exhaustive list, because I'm not equipped to give you an exhaustive list of where issues of locality or something bordering on it crops up. But there's a list there by way of example of where the legislation makes the locality of an activity application for a license crucial. So famously, Section 7 of the Licensing Scotland Act 2005, in relation to over-provision and over-provision policies, it's absolutely crucial as a starting point that the authority defines the locality. But elsewhere in the Licensing Scotland Act 2005, locality comes up directly or indirectly. So, for example, if you look at Section 65 of the 2005 Act, which concerns licensed hours for off-sales, there is expressly a consideration to consider antisocial behaviour in the area. And in that regard, it seems to me there is an interesting interaction with section 24, subsections 4 and 5, 4 and 5E, sorry. And what's interesting about it is that when considering the impact of antisocial behaviour in a locality, or in an area, implicitly of the off sales, that is without prejudice to any issue around the licensing objectives in section 24. So again, the particularities of the area might have to be considered again in a particular context, rather than in the context of the licensing objectives. And then when we look at the Civic Government Scotland Act 1982, if you look at Schedule 1, paragraph 5, subparagraph C, this is about licenses for activities involving the use of premises. Well, they shall be refused if the premises are unsuitable for the activities, having regard to the location of the premises. And there's more to it than that, but one of the considerations is the location of the premises. So again, what might be fine for certain of the activities that are licensed under the 1982 Act in one area would not be fine in another area. So again, you get the sense of Sturges running through the law. Then in relation to taxes under the 1982 Act, section 10, 3 and 3A, contrast unmet need, which obviously is by definition to an area, the area of the local authority, and in turn over provision, which is again by definition to the area of the authority. And then sexual entertainment licenses, Scott's going to say more about that. Section 45C3, they must consider, if they are to have a policy on sexual entertainment venues, they must consider their impact in their area. So whether it's area, locality, definition of location, the importance of location is central to the process of decision making. So that takes us then to how we define a locality, what approach is to be taken to defining a locality. And the starting point here, although it's not said here, I'll make the point shortly. The boards have discretion, a large discretion in terms of defining a locality. The law does not specifically say these are the boundaries by which a locality is to be defined. And so the context, both the legal and the factual context, what it is that's being licensed, the factual context of the activities and the area will determine how a locality, are among the considerations relevant to determining how a locality is defined. Now, certainly a locality must be defined, whichever context it is, a locality must be defined. And when the courts have come to consider how boards in different contexts have defined a locality, their starting point has been one of deference. It has been one of a wide scope of generosity being given to the decision maker. So, for example, in Loosefoot Entertainment, these are all well-known cases, I think, Glasgow city centre was an appropriate locality for an entertainment licence. And that was because the area was, in the words of the sheriff, I think, of known character and fairly well defined. We'll come back to that later. And in the judge's view, it made more sense than having map references by reference to radii and so on from a particular area. So Glasgow city centre, in that case, was an appropriately defined locality. Now, the other extreme in Lazardale and Glasgow licensing board, in that case, it was the radius from the premises which defined the locality. So much more precise, much more narrow definition there. That was the definition of locality that was satisfactory in that case, again, on the factual context. Now, I've taken these quotes from, or this quote from, I think from Loosefoot. I can't be 100% sure. I think it comes from Loosefoot, but the locality, or defining a locality, involves some sense of identity of a community. So there's judicial dicta to that effect, from pretty sure from Loosefoot. And it's not necessarily limited by physical boundaries. So there is something just a little bit more spiritual involved in defining localities. The courts accept that. It's not just a straightforward geographic map reference or concept, the city centre or Leith or something like that. There will be cases where it's appropriate to take into account something a bit more, what's the word I want? Ephemeral, I suppose, or spiritual. And of course, what that then leads to is that localities can change. And so the issue has come up, certainly in England, about the ability of the board to consider the changing nature of a locality when it's renewing a license. So that was expressly accepted in the Birmingham County Council case there, which in Scotland was cited with approval by Sheriff Principal Roxas and Howes, I think, in what I think is one of the landmark cases in certainly in alcohol licensing, the Tesco Stores in Glasgow case in 2013. So it is certainly lawful for the board to consider the changing nature of a locality, yupification, if you like, the sort of 1980s term, as an area changes. Well, so also do the considerations relevant to defining a locality and what is acceptable, possibly with a view to conditions. Now, where we reach, of course, when there is such a wide discretion is that there is, by definition, some arbitrariness involved, and the courts accept that. They recognise that there is, they don't quite put it this way, but in effect, there is some arbitrariness involved in defining a locality. And as the sheriff put it in the Tesco case, while albeit not quite in this context, but the point I think works here too, while consistency might be laudable, inconsistency was only challengeable if it's unreasonable. So it's a very good quote, that I think, from paragraph 32 in the Tesco Stores case. So consistency is great, except when you need to be inconsistent. So what are then the relevant considerations, or some of the relevant considerations in defining a locality? I mean, this you might be thinking I'm stating the obvious here, but, well, geographical considerations are usually a good starting point in defining a locality. So natural boundaries, for example, a river or a main road, or perhaps a forest, or an area where obviously a common ground where housing ends. So there will be often geographical considerations or features which make it logical to define the locality. Local knowledge of how an area is understood. We saw Glasgow city centre a little while ago. So city centre scheme. Things get a bit more vague there, as I was suggesting earlier. I mean, I know Glasgow more than I do Edinburgh, but if you said to a Glaswegian, what's the city centre? I mean, they might say, well, the river to Buchanan Street bus station, to Charing Cross, to Trongate or something like that, or perhaps to the High Court. Although on the edges of that, there will be some debate about whether the Western Brumallow would be the city centre. But you want to get a sense of what the city centre, I think, is, although there inevitably is going to be some marginal debate. But there's certainly going to be a core of it that's pretty obvious. Demographics, or demographic considerations relevant. For example, the population density of an area might lend itself to defining a locality. For example, by contrast with other areas, which if you included them are obviously different because they are less dense. So in a recent case that I think Scott was in, which I cite a reference to it later. Scott might have a better reference. But one of the issues was whether Dundee, that is the Dundee local authority area, if I understand correctly, was a properly defined locality. So it's a bit more than the city centre. And in that case, it was concluded that it was a locality because the population density of Dundee made sense to define it as the locality rather than compared to the population density of surrounding areas. Then there's community need. So that has come up from time to time, certainly in the pre-2005 Act authorities. So in Semple and Glasgow Licensing Board, there was an attempt to define a locality by reference to a community's need. So there was a lot of older people in the area that might want a drink with breakfast, for example, and they couldn't have a drink in the evening because there were far too many drug addicts and the dark nights were unsafe and so on, too much antisocial behaviour on the go. And so did the community need of an area? Was that, or of a particular locality, justified defining the locality by reference to that? And the answer was no, because you couldn't show that this need for breakfasts in the morning was relevant to the license, or all of the things that were said in support of the extended hours application were not relevant to the licensing objectives. So the answer would be, well, yes, possibly, if you can show that these community needs are relevant to the licensing objectives. And then there's community values, and I can't find a perfect case on that. But if you look at Galloway and Western Isles Licensing Board, this basically, as many maybe will remember, concerned an application at a club to serve alcohol on a Sunday. And there were various objections to that. And there's no doubt that the elephant in the room was the religious practices in the Western Isles on a Sunday. That there was considerable opposition from the Free Church and from the Sunday observance groups against this application. But while the refusal of it wasn't expressly rested on Sabbath day concerns, it was clearly that there was a consideration that was present. And because the decision couldn't be justified by reference to satisfactory reasons, or you couldn't work out really what the reasons for the refusal were, but we all suspected what they were. The decision was the refusal of the license was struck down or sent back for proper consideration. But it does give rise to the question of the extent to which community values are relevant, to what extent is it relevant to consider the religious interests and values of a particular community. Now, of course, there may be a particular context, legal context, which influences how localities are defined. So, for example, in alcohol over provision, the Section 142 Licensing Scotland Act, Scottish Government guidance in those paragraphs has a lot to say about drilling down into how you're defining a locality. So where there's guidance, certainly statutory guidance, that would have to be pursued. Now, so far I've been saying all the things that are relevant, but of course there are also irrelevant considerations. And what cannot be allowed in defining a locality is basing the definition on unfounded, or what might be said speculative considerations. So that it would not be permissible to define a locality, for example, on the ground that it is an area where there is too much trouble or too many social problems or too much drinking. There's obviously something unspecific about that. I suppose if you can have an evidence base for it, well, you might be able to argue for something, but if it's unfounded and speculative and based on hearsay, then that would not be an acceptable approach to defining a locality. And you get a sense of that if you look at the Risky Business case in 2000. So on some specifics then, locality and over-provision in alcohol licensing. So the law has a little bit more of a specific nature to say on this subject. So in Section 7 of the 2005 Act, there is an express requirement to define locality within the board's area. So a large discretion is given to boards to define the locality, but they must do that. They must find a rational way of defining the relevant locality. It can be their whole area. That is an option left open to them. And the guidance that I mentioned not only drills down on the approach to defining a locality for this purpose, but it also makes clear that the whole area of the board, they can determine that there's over-provision in the whole area, or they can drill down to different parts of their area, different localities within their area in which they consider that there is over-provision. So how do they approach this task for the purposes of their over-provision policy? Well, a centerpiece of the approach is that they must consult. Here is an example of a statutory duty to consult in Section 6 of the 2005 Act. They must consult specified persons on the question of over-provision, including residents in the locality. So obviously this also means that the locality must be defined for the purposes of the consultation. It's probably going to be the same as the locality that is defined for the purposes of over-provision, but it seems to me not necessarily. You could look at neighbouring areas too, in order to find out what the residents think. And I'm not saying that would be completely that would not be colourable. In some way it might be, but in principle, seems to me there's at least an argument that the locality could mean different things for the purposes of consultation. But the purpose of the inquiry is always in this context, is always to determine over-provision for the purposes of applying the licensing objectives. And in turn, that has given rise to a debate about whether or not the assessment of over-provision and the assessment of compliance with the licensing objectives are two separate matters or part of the same matter. But in the Tesco Stores case, in paragraphs 48 to 53, it was made clear that they are two separate matters. So the board can consider compliance with the licensing objectives, and then they can separately consider and therefore refuse an application on the ground that there is over-provision within the defined locality. Now, what about local knowledge then? This takes us on more or less to the fair hearings issue. So a licensing board is entitled, like all decision makers, it's entitled to draw on its local knowledge when considering the nature of a locality. So it's defined the locality, but now when it's considering applications, it is of course entitled to consider to take into account what it knows about the locality. And that's one of the glories of local decision making. What will the impact of the licensed activities be on the locality, given what the licensing board, the local councillors think about it, ideally, or know about it, ideally in light of the various consultation duties that they have. So certainly defining and understanding the locality is for the board. The court isn't going to, there's a wide latitude given to the decision maker. And that follows from section 7.2 of the Act and the case law that I've been talking about, like Lazardale and Tesco Stores. They have a wide latitude in defining the locality, and it follows from that that they also have a wide discretion in taking into account what they know about it, what they feel or consider to be the particular problems in that locality. But the principles of public law, and in particular fair hearings, obviously require that there's a limit on their use of local knowledge. And what's crucial here is that they do not keep special knowledge to themselves. They don't hold it in and say they know something about this area. They know that there's been a series of incidents or particular issues, and they don't share that with the applicant. That's dangerous territory to fail to inform the applicant about what it is that they're worried about or concerned about, they're thinking about, and what will go on to influence them in their decisions. But when we drill down on local knowledge, there are, of course, implications for local areas of what we might call national issues, and that was one of the issues. That was one of the problems in the recent it's just over a year ago, about a year ago, Aldi Stores and Dundee Licensing Board, which, if occasion requires, Scott was in and can tell us more about. But in that case, as I understand it, one of the issues was whether or not in making their over-provision policy, the local authority, the board, had taken sufficient account of the impact of minimum alcohol pricing or over-provision. The point, I think, being that as alcohol becomes more expensive, the people who are more worried about getting access to it are less likely to get access to it. So you need to think about that consideration, the impact of minimum alcohol pricing when drafting your over-provision policy. And if you hadn't given adequate consideration to the impact of minimum alcohol pricing, your over-provision policy was defective. And the sheriff upheld the challenge on that ground. Now, of course, that does give rise, and there's a little bit of discussion in the judgment about the relevance of this national issue on the locality. The sheriff basically says that, yes, it is a national issue, minimum alcohol pricing, there's national law on it. But how it operates, how it works, is a matter that has to be considered in the locality. So if you failed to consider it, then you haven't come to a lawful over-provision policy. Now, there are also, of course, local issues. At the other extreme, there are local issues in the locality. So there might be a particular problem with antisocial behaviour or drunkenness or deprivation. But if you're going to rely on that, you need to share it with the applicant. And then another case that both Scott and I were in, Motor Fuel Limited and North Lanarkshire Council. Now here, again, it's an example of a national or global phenomenon. The board had refused the licence application on the basis that life was different now after the pandemic and people were drinking too much at home. And if there were too many off sales, then the risk was that people would be going out after lockdown. We hadn't really recovered so much after lockdown, and there was more of a risk of people drinking too much at home, which they thought was relevant to the issue of over provision. Now it may be, but if you go on to decide that issue without clearly canvassing it with the applicant, then you will go wrong, as the local authority did here. So there is, I think, an interesting relationship between global or national phenomenon and how we apply it in the local context. But the crucial consideration is fairness, and some of these authorities, I think, are well known. Certainly Freeland is a leading case. If you are going to decide a matter by reference to considerations, then you've got to raise them with the applicant. So how a board has determined a locality should be notified before the hearing. How it was defined, for example, for the purposes of an over provision policy. Considerations known only to the board about the locality should be raised with the applicant. If the board has something in mind which is going to determine the application, whether it's national or local, should raise it. The best practice, and indeed the law, requires it to be raised with the applicant. But again, maybe not so clear-cut at the edges. There are going to be some matters that are obvious and that don't need to be raised with the applicant. So, for example, the consideration that, or the knowledge that too much drinking caused by over-provision leads to social problems in the locality may be so obvious that it doesn't expressly need to be raised with the applicant, and it's something the applicant should address himself. And we see some discussion in Tesco stores about that. Now, the last one quickly, this is the one that, as I say, I didn't really properly reach. I've mentioned consultation a few times, and I think sometimes we don't drill down enough into what consultation really means. Well, I've asked you the question, thank you for your answer, and I'll make the decision. That's not really meaningful consultation. And here, the starting point is what are called the Sedley Principles, named after, he was then a barrister, Stephen Sedley, later became a judge, as I'm sure you know, who articulated the so-called Sedley Principles, in this case in 1985, ex parte gunning, which has been repeatedly approved by the courts. And some sense of it is actually, a good sense of those Sedley Principles is actually contained in paragraphs 45 to 50 of the Scottish Government's section 142 guidance on over provision. And I've summarised there what it means. And I think the key word there is conscientiously. You've got to listen, and when you get the responses, you've got to conscientiously consider them, which, again, of course, is in the eye of the beholder. And the final point is that when there is no express statutory duty to consult, the circumstances may still require it. I think sometimes with public lawyers, we ignore that point. It's not just an express statutory duty to consult. Clearly, if there is, you must consult meaningfully. But even when there isn't an express statutory duty to consult, the circumstances can give rise to a requirement to consult. And the most obvious circumstance is where basically you've made a rod for your own back and you've decided to consult. And once you have decided to consult, it's not just a matter of grace and favour. All the Sedley Principles then apply when you decide to consult. And that was the case in the Friends of Finsbury Park case. Now, that was an event licence of basically a sort of large-scale festival, which the local residents were very unhappy about and felt that their views had not been properly taken into account. Now, I think, but I can be corrected, that there is not as such a duty to consult in relation to section 40 of the Civic Government Act, but in effect, whether there is or isn't, the nature and scale of an event could arguably give rise to a duty to consult. And when there is such a duty, one way or another, it means meaningful consultation. Thank you. Good. Excellent.
Thank you, Dennis. And both Dennis and Scott have agreed to answer questions at the end, but over a drink in the room next door. So moving on to Scott, I'm sure you all know Scott. Scott has appeared in, I think, just about all the major licensing cases in Scotland over the last 20 years. And so I pass over to Scott to tell us about this very interesting case that he's just been involved in.
Very old. Well, thank you so much for turning out on a dark January night to listen to me in particular. I'll endeavour to spice things up and keep the puns to a minimum given the context of this talk. Performances are available for an appropriate fee later. I'll concentrate on the law just now, if you don't mind. The subject tonight is sexual entertainment licensing. And I was instructed by the City of Edinburgh Council last year to defend a series of decisions taken by the council in relation to the licensing of what are commonly called lap dancing venues. This is inevitably an area of some controversy, as we are dealing here with an area which reasonable people may differ. And that very tension lies at the heart of this licensing regime, because on the one hand, the Scottish Government has said that this is an activity that is capable of being licensed. But on the other hand, there is guidance from Scottish Government which describes sexual entertainment as, in terms, exploitative. It's exploitative of women. So you have this really interesting tension where on the one hand, the government says there is an activity that we are prepared to allow to be licensed as a matter of law, but on the other hand, as a matter of guidance under the legislation in question, we are expressing a view that this is capable of being regarded as exploitation and indeed violence against women in itself. Dancing is violence against women. So there's a real tension here that we don't find in other areas of licensing law. After all, liquor is of course harmful if it's taken to excess, but we don't have a bright line statement from the government saying we're going to license the sale of alcohol, but alcohol in itself is a bad thing. Here we have that tension with sexual entertainment licensing. I should say I don't do slides, technophobe really. I do notes, so I do have detailed notes available after the event if you wish to look at them, so don't feel you have to take notes of what I say. The background to this, of course, has been some 20 odd years, maybe a bit longer in the coming. We had the Risky Business case in the late 90s in Glasgow, where a nightclub was providing entertainment of this kind, but under the character of an entertainment venue providing alcohol, where the dancing was, as it were, part of the entertainment on offer, but was far from being the focus of the venue in question. But it's fair to say over the last 20 or 30 years, sexual entertainment as an activity to which some people at least want to watch and participate in, has become mainstream in the wider licensing sphere, going beyond simply an add-on to licensed premises and becoming the very focus for the business in question. And that's why we got this judicial review, because as you'll be aware, the Air Weapons and Licensing Scotland Act, which is the background to all of this, passed in 2015, amended the Civic Government Scotland Act 1982 to introduce a system of optional licensing, whereby a local authority is entitled but not obliged to license sexual entertainment venues. Interestingly, and I think it has to be said, exclusive to this legislation, this is, I think, the only area, along with sex shops, where a local authority can effectively decide to license an activity on the one hand, and then on the other hand say, we're not going to have any of these things, down with this sort of thing. We will license them, but we're not going to have them. We had that with sex shops since 1982, when the provisions were introduced in relation to sex shops under the 82 Act. And the same model has been adopted, broadly speaking, for the licensing of sexual entertainment venues. There is a definition of what sexual entertainment means, of course, but broadly speaking, it involves performing without your clothes on. We're all adults here, I'm sure I can say that. And normally will involve dancing with a view to, as the legislation says, in sort of wonderfully Victorian language, titillating the audience. I think that's quite old-fashioned language, but there we are, that's what we've chosen. So, it's an optional activity. You don't have to license it. Edinburgh chose to license it. They chose to do so after consulting, what Dennis has been talking about, with the trade, with the community, and with performers, but also with groups who have at the forefront the view that activities of this kind are exploitative. They are the basis for sexual abuse of women, for prostitution, for people trafficking, and so on and so forth. There are viewpoints here, plainly, that not everyone will agree with. But essentially what Edinburgh did was to go out to consultation and to try to establish what the consensus of what the majority view was within Edinburgh on whether these venues, A, should be licensed and how many should we have. Now, it's fair to say, I think just about everyone who responded to the exercise, including the venues in question, of whom there are 5, I think, in Edinburgh, 4 who are looking to be actively licensed, said licensing is a good thing. We think this should be licensed because by licensing an activity, you are likely to thereby regulate it properly, to tackle abuse, to stop bad guys moving into this area and exploiting people. So people were pretty comfortable with the idea of licensing the activity. Where the fault lines appeared, though, was in relation to whether or not the council should decide to license, or rather have a policy on the number of appropriate SEV venues. Should they have a policy which is effectively, we will license existing venues, but no more? Or should we have a policy of nil? Or should we have something in the middle? Should we license 2 out of the 4? Now, Glasgow, I think, and Aberdeen, as I understand it, took the approach of licensing all existing premises, or at least having a policy that existing premises would be licensed, all things being equal, but no more than a current provision. Whereas Edinburgh, on a 5-4 vote, very narrow vote, decided, after hearing from the consultation process and after allowing deputations at the committee hearing on the 31st of March last year, decided on a 5-4 vote that it would be nil. So what does that mean? Well, if you're currently running an adult entertainment venue in Edinburgh, you can continue to trade lawfully. But if you wish to continue beyond the 1st of April this year, when the relevant provisions are fully in law, you need a license. So anyone who's trading just now knows as of the 1st of April, they will need a license from the council. And they're doing this against the background of the council having formed the view that the appropriate number is nil. Now, there are no grandfather rights here. So unlike when we moved over from the 76 Act to the 2005 Act of Liquor, people who were already running a pub were probably going to get a license under the new 2005 Act. You don't have that certainty here. It's a brave new world of licensing. It's a whole new regime. There are no grandfather rights. So if you're running a lap dancing venue, and you're met with a decision of the local authority saying nil, understandably, those businesses have said to themselves, oh, crikey, we're going to be out of business soon because we're going to be refused. If we apply for a license, we're not going to get a license. We're not just a pub or a club that does this as an incidental activity. This is the core of our business. This is why people come to, I think one of them's called Birkin here. I'm sure no one here attends Birkin here, but that's one of the venues. So we get this judicial review, and we had 2 days in the Outer House before Lord Richardson in December. And one of the fascinating stroke, mind-bendingly complicated aspects of this judicial review is it didn't just involve an examination of bog standard licensing law. A number of challenges were brought, which I think illustrates the breadth of issues that the licensing of an activity of this kind can throw up. Not only did we have a challenge brought by the existing operators, but the United Sex Workers, which is a branch of the United Voices of the World, it's a trade union called United Sex Workers, came forward as an additional party. And they were allowed to enter the process and make their own arguments about why having a nil figure would breach their human rights under Article 8 of the ECHR, the right to respect for private and family life. Although paradoxically, one might wonder if you make your living by taking your clothes off in public, is there a private life argument? I'm being slightly facetious, but the point that the performers were making was they're going to be out of a job, and this is how they earn their living, and this could impact on their Article 8 rights in that sense. And it could impact on their families, their ability to pay for their kids' childcare, etc., etc., etc. They also argued that the nil figure would constitute both a breach of the public sector equality duty under Section 149 of the Equality Act 2010, but also direct discrimination under the same act. Why? Well, it was argued that in formulating the figure of nil, the local authority had failed to have due regard to protected characteristics in terms of Section 149 of the 2010 Act, in particular the gender of the performers, because broadly speaking, all, if not almost all, of those involved in this activity, certainly in Edinburgh, are women. So it would have a particular impact on women. The direct discrimination argument, the Section 19 argument, was really a refinement of that broader argument, and it was focused far more on the individual impact on particular performers. And it was alleged that the measure, the nil figure, was a policy, practice, or criterion, PCP, for those of you who do equality law, which was disproportionate and discriminatory in its impact and could not be supported on the evidence. They also argued, and this is, I think, really the philosophically interesting part of this case, is that when you look at the committee recording of the hearing, a number of councillors referred to Scottish Government's Equally Safe strategy. And an attempt was made to argue that the committee had focused on the view that one could equiparate sexual entertainment with violence against women. They're one and the same thing. And it was contended for the union that, well, they're not one and the same thing because, well, here we are, we have lots of women coming forward saying, we perform in these venues, no one's exploiting us. The two don't necessarily hang together. So there's a really interesting issue at the heart of this, is whether and to what extent there is an incoherence between the policy position on one view of Scottish Government, which is this can be violence against women, but it's over to your local authorities to decide whether in your area you will license this sort of activity. So there's a real tension going on there. The other arguments in the case went beyond pure licensing law, where the petitioners also argued that the nil figure was a control on their possessions in breach of Article 1 of the first protocol of the European Convention, and it was disproportionate because the authority didn't have sufficient material to justify a nil limit. They hadn't considered in particular whether the particular aim of protecting women could be achieved by less restrictive means. In other words, perhaps you should just license these places without a limit, or you could have two operating rather than none operating. So ECHR came in there as well. Also, I think of interest to licensing ANARACs is that this is perhaps the first case, although I could be wrong, in Scotland where the Provision of Services Regulations 2009, which of course are European law origin, European directive origin, but brought into UK law by the 2009 regs. They remain in effect, notwithstanding Brexit. And these regulations were relied on again to argue that this went beyond pure Wensbury reasonableness, and the court had to be satisfied that not only were the measures reasonable, the measure was reasonable, but proportionate, objectively justified in European law terms. And we were taken through a tour by counsel on the other side of cases from the European Court of Human Rights about sexual entertainment in the Netherlands, where people sit in windows, I understand, without their clothes on. That's a licensed activity in Amsterdam. And I think essentially the point was being made that when you look at sexual entertainment through a European perspective, they are, I think the comment was made, no sex please, we're British in this country, whereas a European perspective on sexual entertainment is a bit more liberal, and that informs proportionality considerations and how you approach whether these venues should be licensed or not, and whether you should set the limit at 0 or a higher figure. We also had an argument from a Polish gentleman who's a door steward and a European national with retained rights post-Brexit. And he, understandably, was concerned about his job. And he sought to rely on his rights of establishment under the treaties and sought to argue that this measure was an interference, again, a disproportionate interference with his European Union law rights, because, again, it would put him out of a job. Lots in it, isn't there? It's not just about your bog standard licensing and locality and objectives and so on. There's a lot of really meaty public law going on in this case. But in licensing law terms, the position really came down to this. The main criticism of the petitioners was that the legislation says that for the purposes of refusal of an application for a license, you can set a figure, you set it at 0. Having set it at 0, you have no discretion other than to refuse an application when an application is made. In other words, it's a ban, and you've decided in advance that you are banning these types of premises in Edinburgh. And what the petitioners contended was the officers of the council who advised the committee said it's not a ban, it's a presumption against grant. It's a rebuttable presumption. It's a bit like over-provision in liquor. It's not a ban, but we're just letting you know chances are you're not likely to get this if you apply for it, but it's not a ban. And the argument for the petitioner was, well, that's not right. That advice wasn't right. It is a ban, and the councillors thought they had a discretion, even though they were introducing a 0 limit. So they could say 0 for present purposes, but later down the line, they could change their minds about that and say it's not 0. The argument for the council on this point was exactly the opposite, which was, well, no, if you look at the legislation, para 9, subparagraph 5 of Schedule 2 to the 82 Act that deals with SEVs and sex shops, it says that if in the opinion of the authority, the grant of the application would exceed the number for the locality. And the argument there was that, well, that suggests that by the time you come to decide the application, you can have regard to the fact that you've said it will be 0, but on the day you can take a different view. So there is a degree of flexibility, there's a degree of judgment inherent in the exercise, and you're not dealing with this idea of a ban in advance. And there are umpteen arguments going one way or the other on that point, on whether or not we were dealing with a ban or simply a policy position. Now, there are also some other general public law arguments which have cropped up in other cases of late. There was an argument that there was a failure to have regard to Scottish Government guidance. Those of you who do liquor cases will know, and Dennis has mentioned it already, the Section 142 guidance in liquor cases, licensing boards are meant to have regard to the Section 142 guidance. And if you don't have regard to it, arguably that's a public law error. Or if you depart from it without good reason, and you don't give reasons to the Scottish ministers why you've departed from it, that's a public law error. That argument was also advanced in this case because the contention was, broadly speaking, that Scottish Government guidance would not necessarily, if followed properly, lead to the conclusion that sexual entertainment was in itself violence against women. There'd been a misunderstanding about the guidance, even though it seems fairly clear. So you might get, when Lord Richardson writes on this, if he writes on this particular point, some discussion of how a licensing authority has regard to guidance, what it's meant to do with it, if it doesn't follow it, what does that mean? And also, and this is quite interesting, the status of the guidance, because the guidance that was issued was non-statutory. So was it a relevant consideration at all? Should they have regard to it? There was a reasons challenge. Now, those of you who do licensing know that reasons challenges are commonplace. Statement of reasons comes out from the licensing authority. You look at it, you see if there's a ground for challenge. The council did not issue reasons for the decision on the nil figure. There was a discussion at committee. There was a minute, but there's no statement of reasons because the legislation does not require a statement of reasons. But this case is an example of where the petitioner sought to say, well, that's all very well, but fairness requires, it's a bit like Dennis's point about there's no duty to consult, but fairness might impose a duty to consult. There's no duty to give reasons, but you might imply one on grounds of fairness. And we also had this argument here that it was unfair of the authority at the committee not to provide reasons in the normal wordy style sense of adequate reasons. The counter to that was to say, well, A, no duty, and B, in any event, it's obvious what the reasons were, because if you listen to the councillors, they were all saying broadly the same thing about, well, we take the view that these venues are in themselves violence against women, and that was a material consideration that informed the decision of the authority. As to the rights of the European Polish national, the argument there for the council was, well, it doesn't get off the ground because we're not interfering with his employment. It's so remote, because otherwise, if you think about it, you could never close licensed premises down if you had to take into account the rights of the employees at every turn. It's too remote from the licensing decision. On the arguments advanced by the union, position of the council was essentially Article 8 is not engaged, too remote. Article 8 can engage employment, but you have to be someone like Michel Platini, the footballer, before your Article 8 rights are recognised by the European Court. This does not reach the minimal standard to engage Article 8 in an employment context. In relation to the discrimination arguments, the arguments for the authority, again, were essentially there was adequate material before the committee to support A, that they'd carried out a proper public sector equality duty assessment, and B, in relation to direct discrimination under Section 19, that one could justify the restriction in question on grounds of the public interest because there was material before the committee that was capable of supporting the view that venues of this kind should be A, licensed, but B, should be limited to 0. Now, when I put this paper together the other week, I was a bit concerned that by the time I would be speaking to you, the judge, Lord Richardson, would have issued an opinion and I might be saying, oh, right, okay, we don't have it. I'm not sure when we're going to get it. All I know is, and I know Morag's here from Edinburgh, Judith as well, sometime soon, I would expect we might get a decision from Lord Richardson on whether or not any of these arguments stick or whether they don't stick. And I think one can see here that this case, Cagabot Limited against Edinburgh City Council, is illustrative of licensing law cases moving beyond simply the traditional arguments that we all know about in licensing law, reasonableness, natural justice, and so on, and becoming really very sophisticated and calling upon broader public law challenges. And it seems to me that, sadly, if you're a licensing authority, you're going to get more of this stuff because it's out there now and people are arguing these wider public law points in licensing contexts, as well as relying on your retained European law, as well as relying on the European Convention on Human Rights. Who would have thought all of this could come from someone taking their clothes off and dancing in public? We have all this incredibly complicated law, really interesting stuff coming from an activity which for many people might be viewed as something of almost a 1970s Carry On movie, if you're old enough to remember those. I'm sure most of you aren't. But underlying on the surface, the humorous nature of some of this case are some really big issues of social policy, how we view equality, and of course, how licensing tries to resolve the tension inherent in this. How do we license something that the government itself has said has the potential to be a violent activity? Quid juris, which I think is Latin. Thank you very much for listening to me.
Well, thank you very much for that, Scott, and look forward to reading the judgment in due course. I hope you'll all now join us for a drink afterwards. And as I said at the start, the notes and slideshow will be emailed out to everyone that attended tonight. Thank you.